Hello everyone, this week's video is focusing on unfair dismissal and specifically a right which allows employees to potentially bring claims without having the ordinary 2-year service requirement. So irrespective of length of service, employees are protected from dismissal for asserting certain statutory rights in relation to their employment. So we'll look at in this video at how that protection might apply and reflects the fact that dismissals of short-serving staff may not always be risk-free, and this is something that needs to be examined in all cases where businesses are looking to terminate employment possibly more quickly than they would otherwise of somebody with less than 2 years of service. So in addition to protection from ordinary unfair dismissal, the Employment Rights Act and other certain pieces of legislation protect employees from what we call automatically unfair dismissal. So where the reason for their dismissal is one prescribed by statutory provisions. These are also known as inadmissible reasons for dismissal because if they apply, an employee will be deemed to have been automatically unfairly dismissed. The problem there is at that point the claim has already been lost, so recovering that position from an employer's perspective is incredibly difficult because you're essentially looking to either persuade the tribunal that you could have dismissed fairly for another reason, or you're trying to limit the financial damage once it comes to assessing compensation. So as I said, in this video we're looking at asserting statutory rights. So these are certain rights guaranteed by, for example, the Employment Rights Act. So the right not to suffer unlawful deduction from wages, the right to receive a statement of particulars of employment, and more commonly as well, rights guaranteed by the working time regulations. So the right to paid annual leave and certain rest breaks. So if an employee is dismissed and the reason for that dismissal is that they brought proceedings against their employer for breach of a statutory right, or that they alleged the employer had infringed a right which was a statutory one, they are deemed to have been automatically unfairly dismissed. So that means either proceedings must have been brought or an assertion must have been made. So there is case law to support that if an employee makes a statement that their rights will be infringed in the future, that's not enough. They must assert that their rights have already been infringed in order for them to get a claim off the ground. Importantly, it's not absolutely a requirement that the employee has the right or whether that right has actually been infringed. It's enough for the employee to allege that that has happened and that allegation must have been made in good faith. So malicious comments that the working time rights have been breached without any basis or substantial evidence is unlikely to fly, but an employee can be automatically unfairly dismissed for a mistaken belief that the rights have been infringed. In one particular case, an employee believed that he'd suffered unlawful deduction from wages. In principle, that could have amounted to an infringement of a statutory right, even though there was no such unlawful deduction, but the employee believed so. Unfortunately, what he didn't allege was that he'd suffered unlawful deductions. He refused to agree to a contract variation instead, and that wasn't enough. That didn't get over the threshold of making that assertion. In another case, an employee was asked to cover her manager's holiday, which would mean she'd be working for 14 consecutive days without a break. She considered that would be a breach of her rights under the working time regulations, and she complained to her manager. She worked as instructed, but when her manager returned from holiday, she was dismissed. The tribunal rejected her claim of automatic unfair dismissal on the basis that that complaint was forward-looking. So she was told to work 14 days. She alleged that that would infringe her rights, and because those rights had not actually been infringed because the 14 days hadn't been worked, the tribunal said that that claim should be rejected. That was overturned by the Employment Appeals Tribunal, who held it was automatically unfair dismissal. So the breach does not have to have actually occurred, and it was enough that the employee alleged that her rights would be infringed at that time. So it does seem that case law has extended those rights from what the legislation necessarily intended when it was drafted. So employees need to make reasonably clear the statutory right that they allege has been infringed, and they should make clear when, where and to whom the allegations were made and in what terms. Now, the difficulty for employers is that When you are looking to dismiss somebody with less than 2 years of service, you may well consider that the full disciplinary procedure and appeal rights might not apply because there is no right to claim ordinary unfair dismissal. What we need to be aware of, though, is that there is limited protection for employees who might want to bring claims, and it may be the case that this argument is built after the event. It is crucial, therefore, that if you are considering to dismiss, you consider all of the circumstances. Has any complaint been made in the past, even if you believe it was a throwaway remark that somebody was being worked too hard, didn't get enough rest breaks, for example, didn't get enough paid holidays. If we can remember any such comments like that, it may make us tread more carefully when we are coming to dismiss, because there is protection available in limited circumstances for short servers who have their employment terminated. If you do need any further advice on this area, or indeed employment law generally, please do contact us. The website's chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.